Hey everybody, Jeff Cooper here of Cooper Estate Planning and Elder Law. Listen, I wanted to talk today about a topic that I think is a source of confusion for a lot of people, because I hear this from prospective clients all the time. By the time people are my clients, of course, they're up to speed and they're educated on this stuff. But when people originally come to me, they don't necessarily understand what does a trustee do, what does a financial power of attorney agent do, and how do those things kind of intersect, if at all, or overlap or whatever. So there's a few kind of differentiating things there. And I would say, first off, that in terms of a similarity, both are fiduciary responsibilities, right? Your power of attorney agent is a fiduciary, has fiduciary responsibility. Your trustee has a fiduciary responsibility to the beneficiaries of the trust, not necessarily to the person who created the trust. That's another topic for another day. But the big difference there is that under the financial power of attorney document, that agent does not have any responsibility, any obligation whatsoever to act on your behalf. They don't have to do anything. They can be named as power of attorney agent and just sit on their hands. It's like maybe a football game. They can just take a knee and do nothing, or they can not enter the game. Or in some cases, they may not even be aware that they've been named as a power of attorney agent. Now, in contrast to that, your trustee is going to be someone who has actually signed the trust document. In a technical kind of fundamental, rudimentary sense, the trust is a contract between the person or people or entity who sets it up, the person or people or entity who acts as a trustee, and the person or people or entity and or entities who are the beneficiaries of the trust. Okay, so your trustee has to know that they're involved in the trust. There's no other way about it. They sign on to take on that fiduciary responsibility. So they have an obligation to act on your behalf. Okay, your power of attorney agent doesn't even necessarily know that they've been named as your power of attorney agent. Now, I don't recommend doing it that way, okay? Please let them know. But that's kind of one big difference. Another thing I would point out is that these people or entities or persons or whatever, they may have authority to act with respect to completely different property. So if I have, let's say I set up a trust and I fund it with some things, I put maybe a parcel of real estate in there, I put a bank account and a life insurance policy into the trust, okay? My trustee, if it's me, great. If it's not me, in some situations it may not be me, for whether for asset protection purposes or for maybe in situations where I'm not able to act as trustee, okay? My trustee acts on my behalf, and with respect to that property, they can only act with respect to that property. They cannot also turn around and make transactions in my personal bank account or call T-Mobile on my behalf, or in contrast, act with respect to a bank account that's owned by me as an individual. Okay, they can't do that. Now, there are certain situations where your power of attorney document might give your agent the authority to do some things pertaining to your trust. That's, again, another matter for another day. Not a very common situation, but it's possible. So we do that once in a while. And oftentimes those are the same people. Your power of attorney agent might well be your trustee, but they're going to act with respect to different property. So I might put on my trustee hat and do some things related to the house or whatever else is there owned by trust. And I might put on a different hat and do some activities related to the things owned by the individual who I represent as their power of attorney agent. Okay, so two different things. And the last thing I thought I would point out is that your durable power of attorney document, your financial power of attorney document, it helps. It gives someone the ability to speak on your behalf in a legal or financial context. That is something that allows that person to step into your shoes and do the things that you would do, but it's an offensive tool. It's something that they can use to get things done. It is not something that they can use to keep someone else in your family scenario or whatever that looks like from attacking what you have. Okay, so if you want some kind of defensive protection around those things. That's probably more likely to come from a trust scenario or some kind of guardianship situation if you're a person who is unable to manage your own affairs permanently, that type of thing. So a little too much information probably, but thanks for sticking around. Again, Jeff Cooper, Cooper Estate Planning and Elder Law. Let me know if you have any questions. Thanks a lot. Take care.